Yes.
Good morning, sir. Are you Kelvin Johnson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will.
Judge, with the court's permission, we need to go on second degree count, so whichever the court prefers.
Somebody didn't sign.
The defendant, I signed in the wrong spot. Sorry.
Oh, I didn't get him.
That's okay. Mr. Johnson, in cause number 25, DCCR 1781, you're charged with the state jail felony offense of theft of property with previous convictions from October 9th of 2025. The indictment alleges you were previously convicted of theft August 18th of 2022 and January 5th of 2023, and then April 15th of 2024. The indictment further alleges that you were convicted of delivery of a controlled substance, a state jail felony, February 9th of 2004, 2 cases on that same date of delivery of a controlled substance. And how do you plead to that charge? And are those prior convictions all true?
Yes, ma'am.
Did you enter your plea of guilty and true, freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yeah.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison, which means you're leaving your punishment up to me. And as long as I follow the agreement, I cannot give you more than 5 years. Give you 5 years, I can give you less, I can consider probation. All of that will be determined when we come back for sentencing and I get more information and a pre-sentence report and things like that. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, then you're waiving that. And is that what you want to do? Right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. I find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do that report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come.
Yes, ma'am.
All right, we'll see you back at sentencing. You go back with the bailiff. Then you've got Willie Pew.
It's gonna be a rejection.
Good morning. Are you Willie Edward Pew Jr.? Give me just a second, Mr. Pew, to get this pulled out. Mr. Pew, in cause number 25, DCCR 1835, you're charged with a 3rd-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the 3rd-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. 2 cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a 3rd-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony. And unlawful possession of a firearm by a felon also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. To go forward, probably on, it looks like counts 1 and 2, that would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reason for the.
Um,
And
I
Judge,
could do that very quickly.
if you'd rather just reset a week or two.
I would like, I mean, I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
This might read different on the from because the
Okay.
conversation.
Sure, yeah, that's good. Brian Trejo,
I'm gonna ask for a reset on that, Judge. I'm still trying to run down witnesses that were.
okay, it's pretty new. Mr. Nichols, and we'll set Brian Trejo. I think that's all you have.
Sarah Jordan's gonna be reset along with the co-defendant.
I think I already got
Okay.
that one. Yeah,
That's it. Thank you.
thank you.
Good job. Good job.
Mr. Parker,
Yes, ma'am.
you've got Christopher Holman. Okay.
I got to text with the guys. If we go out on the news thing, he groovy from office, send me a picture. Parker's crawling.
Mr. Coleman,
Morning, Judge.
we need them to get a fingerprint real quick first, please.
I got everything resolved with you. It's only Ashley that I'm.
I wasn't trying to call out anybody,
Pretty bad.
I'm just pointing you.
We did. Thank you. I will maybe this week.
Good morning, sir. Are you Christopher Holman? Speak up, please.
This one.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Holman, in clause number 24, DCCR 0814, you're charged with the state jail felony offense of theft of property with previous convictions from February 7th of 2024. The indictment alleges you were previously convicted of theft August 4th of 2020, and then after that was final August 10th of 2021. And how do you plead to that charge?
Guilty.
And are those prior convictions of theft true? Speak up, please.
Yes, ma'am.
And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with. I have here on the tablet some documents that have your signature on them, that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Holman is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. And at this time, in accordance with your agreement, find you guilty of theft of property, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff.
3 defendants, 3 criminal histories, 1 courtroom holding it all together. This session captured what happens when the justice system confronts repeat offenders. Men with criminal records stretching back decades, standing before a judge who has seen their names before. First, Kelvin Johnson, facing a state jail felony theft charge, his 4th theft conviction, plus prior drug delivery offenses going back to 2004. He entered a guilty plea under a capped agreement of no more than 5 years. The judge accepted his plea, found him competent and voluntary, and reset the case for sentencing pending a pre-sentence report. The door to probation remains open, but that door swings entirely on what that report reveals. Then Willie Pew Jr., a man whose criminal history reads like a cautionary timeline. Unauthorized use of a vehicle, unlawful firearm possession, drug possession, evading arrest. His latest charge? Felon in possession of a firearm again. If convicted at trial, he's looking at a habitual offender enhancement, a minimum of 25 years up to life. He rejected the state's 14-year offer, but the prosecutor flagged a potential issue with the search, and the judge wisely reset the case to let both sides reassess. That decision could change everything. Finally, Christopher Holman, a theft repeat offender who took the plea deal. The judge sentenced him to 15 months in state jail. Clean, final, done. 3 cases, 3 different outcomes at 3 different stages. But the through line is unmistakable. Pattern behavior collides with judicial accountability, and the courtroom becomes the place where consequences catch up. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.